In this lecture, we shall discuss the challenge of public elections. Our goal is to achieve an explanation of what public elections are, and then we look at the different procedure for challenging presidential elections as opposed to parliamentary elections. And then we shall then look at the court that has jurisdiction to hear actions pertaining to the challenge of the elections of the President of Ghana. And then we shall also look at the court that has jurisdiction when it pertains to challenging parliamentary elections in Ghana. And then we shall then look at the people that have capacity to bring an action to challenge the election of a president of Ghana. And then we shall also look at the capacity of persons who can bring an action to challenge a parliamentary election in Ghana. So when it comes to a challenge in respect of a presidential election, Article 64 of the 1992 Constitution is very instructive. Article 64 of the 1992 Constitution provides as follows. It indicates that, and I quote, that the validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the results of the election in respect of which the petition is presented. So under Article 64, Clause 1, there are critical points that we must note. Number one is that it is only the Supreme Court that has jurisdiction when the petition is in respect of challenging the validity of the election of the president. And then the capacity is given to a citizen of Ghana. And then also, the citizen of Ghana must bring the petition within 21 days after the declaration of the results of the election in respect of which the petition is presented. So under Article 64, Clause 1 of the Constitution, we know that the validity of the election of the president may be challenged by a citizen of Ghana. The petition has to be brought within 21 days, and it must be brought within 21 days after the declaration of the results of the election in respect of which the petition is presented. And remember that the timeline is within 21 days after the declaration of the results. Now, it is important for the legal practitioner that as far as the challenge of the presidential election is concerned, that you are familiar with the Supreme Court's Amendment Rules 2012 CI 74. That is the regulations that govern the Supreme Court in respect of election petitions of the president. And then let's move on to parliamentary elections. Now, for parliamentary elections, the provisions of the Constitution that are very instructive mainly Article 99 of the Constitution. Article 99 of the Constitution is very instructive as far as the jurisdiction to hear parliamentary election petitions is concerned. What does Article 99 say? Article 99 indicates that the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of parliament or the seat of a member of parliament has become vacant, or B, a person having been validly elected as a speaker of parliament or having been so elected has vacated the office of speaker. So what we see under Article 99 is that as far as parliamentary election petitions are concerned, the Constitution has given the jurisdiction to the High Courts under Article 99 of the Constitution. Because Article 99 says that the High Court shall have jurisdiction to hear and determine any question, A, whether a person has been validly elected as a member of parliament, or any question about the seat of a member of parliament having become vacant. And so under Article 99 of the Constitution, the jurisdiction to hear parliamentary election petitions is given to the High Court under Article 99. Now, there is an interesting provision about Article 99 that is worth discussing. Clause 2 of Article 99 reads as follows, and I quote, that a person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal, full stop. That a person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal, full stop. And so there's no provision that is made under Article 99 that whenever you are also dissatisfied with the decision of the Court of Appeal, you can also go to the Supreme Court. Article 99 only says that the High Court has jurisdiction when you are challenging issues pertaining to the election of somebody as a member of parliament. And it says that if you are dissatisfied with the High Court decision, you can appeal to the Court of Appeal. Take note that nowhere in Article 99 is there any statement that if you are not happy with the Court of Appeal's decision, you can appeal to the Supreme Court. But Article 131 of the Constitution has language to the effect that an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court as of right in a civil cause or matter, in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court. What it means is that under Article 131 of the Constitution, the Constitution has clearly indicated that when there's a matter that's originated at the High Court and an appeal has gone to the Court of Appeal in respect of that matter that started at the High Court, under Article 131, it says that an appeal shall lie from that judgment of the Court of Appeal to the Supreme Court. And it is important to note that this provision under Article 131, it is found in the chapter of the Constitution that relates to the Supreme Court. So the question is this: Article 99 indicates that when you have any action that is pertaining to you challenging that a person has been validly elected as a member of parliament, if you have any of those parliamentary actions under Article 99, the court that has original jurisdiction is the High Court. And that Article 99 says that if you are dissatisfied with the High Court decision, you can go to the Court of Appeal. But nowhere in that Article 99 have we said that when you are not happy, you can further go to the Supreme Court. But we have seen Article 131 of the Constitution, which is a general provision indicating that an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court. So the question is that in parliamentary election petitions, when you originate your action at the High Court, and then if an appeal is made to the Court of Appeal, can a person come under Article 131 and then lodge a further appeal to the Supreme Court? That is the question. The answer is no. The answer is no, because under Article 99, which is the article in the Constitution that specifically governs election petitions in parliamentary matters, the only right of appeal provided in Article 99 says that you shall only appeal to the Court of Appeal. That provision in Article 99 hasn't made any provision for a further appeal to the Supreme Court. And therefore, the question is that whenever you have an action which is an election petition about a parliamentary matter, the final Court of Appeal is the Court of Appeal, and you cannot go to the Supreme Court. And this position that I have indicated is supported by the case of in parliamentary election for Woodlands constituency, Zakaria versus Nimakine. Zakaria is spelled Zakaria versus Nimakine, Nyimakan, reported in 2003, 2004, one Supreme Court of Ghana law report at page 1. In this case, the question arose as to whether, in respect of parliamentary election petitions, the final Court of Appeal was the Court of Appeal or the Supreme Court. And the court held that if it relates to a parliamentary election petition, then the final Court of Appeal in some matters is the Court of Appeal and not the Supreme Court. And this is how Dr. Sechtum, who ruled for the majority, this is how he answered the question, and I quote, "The final matter raised by the respondents, as we have stated earlier, is based on the maxim generalia specialibus non derogant. Into bracket, general words do not derogate from special. This maxim may be explained as follows. Where there is a general enactment in a statute, which, if taken in its most comprehensive sense, would override a particular enactment in the same statute, the particular enactment must be operated, and the general enactment must be taken to only affect other parts of the statute to which it may properly apply." Now, let me pause here and explain this maxim of generalia specialibus non derogant. It means that when you have a statute And there's one provision in the statute which is of a general nature. It's supposed to have a general applicability. And you have another provision which is supposed to have a special effect. The provisions which have a special effect will be deemed to override the general ones. This maxim has become important in this case of Zachariah and Yimakine because Article 99 of the 1992 Constitution is a provision that specifically deals with election petitions relating to parliamentary elections. That is the specific and special effect of Article 99 in the 1992 Constitution. Article 131 of the Constitution is a provision which is of a general nature. It deals with the general appellate jurisdiction of the Supreme Court, that in any civil cause or matter, an appeal shall lie to the Supreme Court. It is of a general nature. Nowhere does it mention parliamentary elections. So the argument of the respondent in the Supreme Court is that since in the Constitution there is a special provision in Article 99 which is specifically there to deal with parliamentary election petitions, when there's a conflict between that special provision in Article 99 and the general provision in Article 131, the argument of the respondent is that the special provision in Article 99 is supposed to prevail over the general provision under Article 131. And that is why the respondent was arguing that if Article 99 prevails over 131, Article 99 will prevail and make sure that the final court of appeal in parliamentary election petitions is the Court of Appeal. Because Article 99 never mentioned that whenever you are dissatisfied with a Court of Appeal's decision, you can go to the Supreme Court. It never mentions that. Before reading further the dictum of Dr. Chun JSE, let me once again read Article 99 of the Constitution and Article 131 so that you can appreciate why the argument is being made that Article 99 is a special provision and Article 131 is a general provision. So 99 reads as follows, and I quote, "The High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament, or the seat of a member has become vacant, or B, a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker." Then clause 2 of Article 99 reads as follows, "A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." You can see that the whole of Article 99 only deals with elections pertaining to members of Parliament or the Speaker of Parliament. But look at the language of Article 131 of the Constitution. Article 131 says that an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court as of right in a civil or criminal cause or matter, in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court. And also, if you look at Article 129 of the Constitution, it says, "The Supreme Court shall be the final court of appeal and shall have such appellates and other jurisdictions as may be conferred on it by this constitution or by any other law. So you can see that Article 129 and Article 131, nowhere do they make mention of parliamentary election petitions. So they are general provisions that deal with the appellate jurisdiction of the Supreme Court. But Article 99 is a special provision that is specifically dealing with election petitions relating to parliamentary elections. So it is because of this position of Article 99, 131, and 129 that the respondent anchored his argument on the maxim of generalia specialibus non derogant. And so let me now read again the dictum of Dr. Chum JSC so that now you can appreciate it better. It says as follows. The final, and this is still the case of Zachariah versus Nimakine. The final matter raised by the respondent, as we have stated earlier, is based on the maxim generalia specialibus non derogant. Into brackets, general words do not derogate from special. This maxim may be explained as follows. Where there is a general enactment in a statute, which if taken in its most comprehensive sense, would override a particular enactment in the same statute, the particular enactment must be operative, and the general enactment must be taken to affect only the other part of the statute to which it may properly apply. The appellant has argued that the plain and ordinary meaning of the said relevant provisions of the Constitution, which spelled out the appellate jurisdiction of the Supreme Court, namely Article 131 clause 1A, equally is clear and unambiguous and admits of no over-elaborated construction. The real matter for decision is whether the special provision set out in Article 99 clause 2 for appealing against a High Court determination under Article 99 clause 1 should give way to the general jurisdiction given to the Supreme Court by Article 131 clause 1A. In our humble view, the matter is clearly covered by the above cited maxim. Dr. Chum JSC proceeded as follows, and this is still the case of Zachariah versus Nimakine. And I'm quoting, admittedly, in a wider sense, it may be said that Article 131 clause 1A should give a further right of appeal to the appellant. But as we have pointed out above, Article 99 clause 1 creates a special remedy. And in that remedy, the appeal process ends at the Court of Appeal. Article 99 clause 2. It is quite clear that the framers of the 1992 Constitution intentionally did that. Dr. Chum JSC proceeded as follows, and this is still the case of Zachariah versus Nimakine, and I'm still quoting. It cannot be said that when they wrote Article 99 in the form we find it in the Constitution, they were oblivious of the general appellate jurisdiction of the Supreme Court. We are fortified in our view by a consideration of Article 33, dealing with fundamental human rights remedies. By Article 33, Clause 3, a further right of appeal is expressly enacted, giving the Supreme Court jurisdiction. This gives the clearest indication of the intention of the framers of the Constitution, that they deliberately discriminated between appeals against election petitions and fundamental human rights appeals. In order that the clear intention of the framers of the Constitution may not be aborted, we are convinced that this is a proper case to apply the maxim generalia specialibus non derogant. We hold that the appeal provision in Article 99, Clause 2 supersedes the general appellate jurisdiction of the Supreme Court in Article 131, Clause 1a. We hold that there is no right of further appeal from the Court of Appeal to the Supreme Court. Consequently, we declare that this court has no jurisdiction to adjudicate on the substantive appeal filed in this matter by the appellant. These are the words of Dr. Chung JSC in the case of Parliamentary Election for Woodlands Constituency, Zachariah versus Yimakine, 2003-2004, 1 Supreme Court of Ghana Law Report at page 1. So what we have done so far in this lecture is this. We have identified that if you want to challenge the election of the president, the validity of the election of the president, the operative article is Article 64 of the 1992 Constitution. And that article provides that the court that has jurisdiction in presidential election petitions is the Supreme Court. We have also taken a look at Article 99 of the Constitution that provides that in parliamentary election petitions, the court that has jurisdiction is the High Court. And an appeal from the High Court in respect of a parliamentary election petition shall lie to the Court of Appeal with no further right to the Supreme Court. And this is supported by the case of in-rep parliamentary election for Woodlands constituency, Zachariah versus Yimakine, 2003-2004, 1 Supreme Court of Ghana Law Report at page 1. Now, the next thing is to look at the timelines for bringing presidential election petitions and parliamentary election petitions. The timelines for bringing presidential election petitions and parliamentary election petitions. Now, when you look at the language of Article 64, Clause 1 of the Constitution, it indicates that the election petition, which is for the purpose of challenging the validity of the election of the president, it may be brought within 21 days after the declaration of the results of the election in respect of which the petition is presented. Again, usually when you ask students, what is the timeline for bringing the election petition, if you are challenging the validity of the election of the president, then they only say 21 days and they leave it there. When you just say 21 days, you haven't said anything. You must add, within 21 days after the declaration of the results of the election in respect of which the petition is presented, then you have answered the question well. The timeline is very important. Within 21 days after the declaration of the results of the election in respect of which the petition is presented. That is Article 64 of the 1992 Constitution. And it shows us the timeline we have to bring the election petition if it is in respect of a presidential election petition. Now, what if the election petition is in respect of challenging the validity of the election of a member of parliament? What is the timeline you have to bring the action? The answer is found in section 18 of the Representation of the People Law, 1992, PNDC Law 284. Representation of the People Law, 1992, PNDC Law 284. Like I said, the answer as far as the timeline for bringing a parliamentary election petition is in section 18 of the Representation of the People Law, 1992. This is what section 18 says, and I quote, "An election petition shall be presented within 21 days after the date of the publication in the Gazette of the results of the election to which it relates. But a petition questioning an election on an allegation of corrupt practice and specifically alleging a payment of money or any other award to have been made by the person whose election is questioned or to have been made on behalf of and to that person's knowledge may be presented within 21 days after the date of the alleged payments," and the quote ends. Now, the timeline for this thing, it is so crucial because if you look at section 18 clause 3, it says the time limit provided by this section for the presentation of an election petition shall not be extended. And so the timeline for bringing the election petition in respect of a parliamentary election petition is very crucial. Let me take section 18 and draw your attention to the relevant aspects of it. The first part says, an election petition, and this is in respect of parliamentary election petition. An election petition shall be presented within 21 days after the date of the publication in the Gazette of the results of the election to which it relates. So how can we distinguish this from what we saw under Article 64 of the Constitution? Article 64 says that you can bring the petition, you must bring the petition within 21 days after the declaration of the results. But when it comes to parliamentary election petitions, they didn't say within 21 days after the declaration. No, they said within 21 days after the date of the publication in the Gazette of the result of the election to which it relates. That is very important. That's the first part of section 18 of the Representation of the People Law, 1992. Within 21 days after the date of the publication in the Gazette. Now, the second aspect is what is very crucial. And that is what I'll take a lot of time to explain. The second aspect of section 18 of the Representation of the People Law, 1992, reads as follows. That a petition questioning an election on an allegation of corrupt practice and specifically alleging a payment of money or any other award to have been made by the person whose election is questioned or to have been made on behalf of and to that person's knowledge may be presented within 21 days after the date of the alleged payment. So the second aspect tells us that if the crux and the government of your action is that you are alleging corrupt practice and you are alleging the payment of money made by on behalf of the person whose election is questioned, for that one, you may present your petition, within 21 days after the date of the alleged payment. This provision here would ordinarily mean that you would not have to wait for the result of the election to be declared. But that would be a very dangerous conclusion to come to arrive at. The Supreme Court has had the opportunity to throw more light on the second aspect of Section 18. Because, like I said, Section 18, the second aspect says that you can bring the action within 21 days after the date of the alleged payment, presupposing that you may not even have to wait for the results to even be declared. As soon as the payment is made, then you can then go to the court. But that is not the case. That is not the case. So please do not take Section 18 of the Representation of the People Law 1992 just on the face value. Do not think that because it says that you can bring the action within 21 days after the date of the alleged payment, then you can go even if the result has not been declared. And I'll give you the answer on why I'm saying that. The answer can be found in the case of Republic versus High Courts, Koforidua. Ex parte Dr. Kofi Asari reported in 2009 Supreme Court of Ghana Law Report at page 460. It is Republic versus High Court, Koforidua, ex parte Dr. Kofi Asari, Baba Jamal Mohammed Ahmed, and two others interested parties. This is a case that I would advise all of you to read. And you see this case very, very interesting. In fact, the brief facts of the case that can be gleaned from the dictum and the judgment of Answer JSC are as follows, and I quote, "This is a matter concerning the conduct of the 2008 parliamentary elections in the Akwetia constituency. On the 22nd December 2008, the first interested parties herein, Mr. Baba Jamal Mohammed Ahmed, Mr. Samuel Abokwa, and Mr. Basil Ahiable, issued a writ of summons against the Electoral Commission, the second interested party, claiming declaratory and other reliefs. On the same day, the first interested parties also filed a motion on notice for an interim injunction to restrain the Electoral Commission from organizing the special and the general voting exercises in the constituency, scheduled for 23rd and 28th December respectively, as part of the nationwide elections in 2008 that went to the runoff stage. Following the above legal actions, voting was not conducted for 6 polling stations in the Akwetia constituency. And as of now, the Electoral Commission has not declared a winner in the Akwetia parliamentary electoral exercise. The applicant herein, who had applied and had been joined as the second defendant in the action, filed an application challenging the competency of the writ to initiate what, in his considered opinion, was an election petition. The High Court, Koforidua, presided over by His Lordship Justice G.S. Subare, delivered a ruling on the application, stating that a writ was competent to commence the action, and therefore the High Court was clothed with jurisdiction to hear and determine the case. It is this ruling of the High Court that the applicant is praying this honorable court to quash. And then the quote ends. What we can get from the facts are as follows. That 1, a writ had been issued, and then an injunction had been obtained. And all of these were done in the High Court. by virtue of this writ and the injunction, the election had not been conducted. Now, an application was made before the High Court judge that the whole action was in fact an election petition. And if it was an election petition, it was premature for the action to be filed in the High Court. Because as we know from Section 18 of the Representation of People Law, we know that if it's an election petition, you must rather commence the action within 21 days after the publication in the Gazette. So the applicant before the Supreme Court hearing is arguing that since this is an election petition, then it is premature because it rather has to be brought within 21 days after the publication in the Gazette. Now you will notice that in this case, the election results have not been declared. So there's no election results as of now. But the plaintiff in the High Court, because no results have been declared, what he rather found at the High Court was a writ of summons. Now, his argument was that insofar as the results have not been declared, then there's no election conducted, which would require him to rather file an election petition. And that since no results have been declared, he could bring the action by filing a writ of summons. In this particular parliamentary election exercise, no results have been declared, no person has been declared a winner of the election. And so that is why the lawyer for the plaintiff rather issued a writ of summons in the High Court. And so in the High Court, when the objection was raised that the persons had to rather file a petition and not a writ of summons, the High Court indicated that since no results have been declared, then you cannot have an election petition. So when the High Court judge was assuming jurisdiction in the matter, this is what the High Court judge said in his ruling, and I quote, "It is only when the action relates to the determination of the validity of the election of a person as a member of Parliament after an election has taken place and the results declared, and someone further declared winner or duly elected member of Parliament for the particular constituency, that one must proceed by a petition." And the quote ends. Now you realize that the High Court judge is saying that, well, no results have been declared, nobody has been declared winner. So there's no point in us saying that you should come with an election petition. And that was why the High Court judge indicated that, well, that is why they had to file the action with a writ of summons and not with a petition. Now, to buttress the arguments of the plaintiffs, the whole of the lawyers' arguments in the High Court was that the reliefs that they had endorsed on their writ of summons, even though they pertained to the parliamentary election in the Akwatia constituency, they were different from reliefs that a petitioner in an election petition would normally seek under the Representation of People Law, and therefore he could come by a writ of summons. Now, the High Court judge indicated that yes, even though the plaintiffs had filed a writ of summons, the essence of their action was not to challenge the validity of the election of anybody as a member of Parliament. And as such, the writ of summons was appropriate in such a case. Now, even though the plaintiff's lawyer was saying that it was not an election petition, look at the first claim that they had endorsed on their writ of summons, and I quote, A declaration that the general conduct of the parliamentary election in the Akwetia constituency was characterized by such extensive and pervasive electoral irregularity, and that they may reasonably be supposed to affect any declared outcome thereof. Now, if you look at the substance of this relief, that they are looking for a declaration that the general conduct of the parliamentary election in the Akwetia constituency, it was characterized by such extensive and pervasive electoral irregularity that they may reasonably be supposed to affect any declared outcome thereof. Now, the Supreme Court noted that at the end of the day, if you look at this kind of relief you're asking for, that the whole election at the Akwetia constituency was characterized by extensive irregularity and it will affect the outcome of any result, you are invariably trying to challenge and render the whole parliamentary election over there void. Anyway, having said so, let us see how the Supreme Court addressed the issue. One of the questions the court was supposed to decide on was that what is an election? Now, in order to resolve this issue of what's an election, because it's out of an election that you can have an election petition. Now, in one case, that's really helped the courts in determining what an election or election petition is. It's the case of Republic versus the High Court Judge, Sunyani, ex-party, Alhaji Collins Dauda. CM, JM, stroke 12, stroke 2009, dated 8th of April 2009. Now, you see, in this case, Dr. Bandiesi gave a judgment in this case, and that is what formed the foundation to determine how we can determine what an election petition is. So I'll quote from ex-party Collins Dauda, so that we will see how an election petition was defined in that particular case. And this is what the court said, that the Bandiesi said in Republic versus the High Court Judge, Sunyani, ex-party Collins Dauda. And I quote, that it is clear from the language of section 18 of the Representation of the People Law, 1992, that an election petition may not be presented before the results of the election concerned have been declared by the Electoral Commission and in some cases gazetted. Where the petition is based on an allegation of corrupt practice and specifically alleges a payment of money or other award on behalf of the person whose election is questioned, the petitioner need not wait till the publication in the Gazette of the results. Rather, he or she may bring the election petition within 21 days after the date of the alleged payments. It is this provision which has probably misled the interested party, in this case, into presenting his petition, his election, before the High Court. We say because the time limit of 21 days, if not read in this context, could be interpreted literally to mean that the petitioner can bring his petition within 21 days of the alleged corrupt practice, whether or not the election result has been declared. I'll take that portion again. And I'm still quoting from Republic versus the High Court Judge, Sunyani, ex-party Collins Dauda. Say that we say misled because the time limit of 21 days, if not read in context, could be interpreted literally to mean that the petitioner can bring his petition within 21 days of the alleged corrupt practice, whether or not the election result has been declared. This is, in fact, the interpretation that the interested party has urged on this court quoted from a statement of case. The obstacle to this interpretation is the expression, the person whose election is questioned in section 18(1). This expression has to be construed in its context as logically implying that an election must have taken place and its results declared by the Electoral Commission. Otherwise, there would be no person whose election is being questioned. Now, after referring to the quote from the ex parte Collins Dowda has ended. So now, the court, after quoting this position in the ex parte Collins Dowda, had to draw some inferences. Because remember, we are in this case of ex parte Dr. Kofi Asari, that is the Akutia constituency election. We are in that case trying to find out that this action they have brought in the High Court by a writ of summons when they didn't come with the petition. Was it an election petition? Because remember, no results have been declared yet. If it was supposed to be an election petition, then they were supposed to have come by what? An election petition rather. But if they're not challenging the whole parliamentary election, then they could go by something else. Now, as per the Collins Dowda, we have given some guidelines and some inferences can be drawn from this as per the Collins Dowda case. Because if they are challenging the validity of the election of somebody, then they rather have to come by a petition. But their argument is that no person has been declared elected, so there was no need for them to go by a petition. Now, these are the inferences that Answer GSC drew from the ex parte Collins Dowda case. And so this is what Answer GSC said, and I quote, the law is now settled. The law now is settled that an election within the meaning of PNDC Law 284 is that in which the Electoral Commission has at least declared a result. This has been the position of the Supreme Court in the case of Republic versus the High Court, Sunyani, ex parte Collins Dowda, wherein Dateba JSC, delivering the unanimous decision of the Supreme Court, held at page 9 of the judgment as follows, and I quote, accordingly, our conclusion from reading the provisions of PNDC Law 284 together is that even in the case of an allegation of a corrupt practice, an election petition may be brought only after the Electoral Commission has declared a result in the election in relation to the election. Again, and these are the words of the Dateba GSC from ex parte Collins Dowda, and I'm quoting once again. Accordingly, our conclusion from reading the provisions of PNDC Law 284 together is that even in the case of an allegation of a corrupt practice, an election petition may be brought only after the Electoral Commission has declared a result in relation to the election. Quote ends. Then Answer GSC continues. The court also stated that anything short of a declaration of a result by the Electoral Commission in the election will not qualify it as an election within the meaning of PNDC Law 284. The court stated at page 8 of the judgment as follows, and he's referring to ex parte Collins Dowda, and I quote, it can be cogently argued that an election whose results have not been declared is an inchoate or incomplete election rather than an election. And the quote ends. Then Answer GSC continues in ex parte Dr. Kofi Asari as follows. What this means is that an electoral exercise in which the Electoral Commission has not declared a result in relation to it is an incomplete or inchoate election, and an incomplete election is not an election. Now, what we have obtained at this point is that in the Akutia election as it stands now, the substance of whatever has happened is that there have been no declaration of the results. And the plaintiffs had filed a writ of summons in the High Court. Now, if you go by the ex parte Colin Dowda case, there is no complete election in that particular case. So if there's no complete election, can anybody then go and file a writ of summons? In other words, should they have rather come by a petition? The plaintiff's argument was that since the results have not been declared, then that is why he came by a writ of summons. Because if you go by the ex parte Colin Dowda case, there is no election that has been properly conducted, and that whatever has happened is an inchoate election. That is why they went by a writ of summons and not the petition. Now, even though the results have not been declared, it will be helpful at this point to restate the reliefs that the plaintiffs in the High Court, the reliefs that they were seeking in their writ of summons and statement of claim. And let me quote once again the reliefs they were seeking. The first claim they endorsed on their writ was as follows, and I quote, a declaration that the general conduct of the parliamentary election in the Akwitia constituency was characterized by such extensive and pervasive electoral irregularity that they may reasonably be supposed to affect any declared outcome thereof. Quote ends. Now, as GSC is saying that if you look at the relief that you are seeking, in substance, what you are seeking to do is to declare the entire parliamentary elections in the Akwitia constituency as void. Now, if we uphold that particular relief that you're asking for, it goes to affect the validity of the election over there. And if you are going to affect the validity over there, then you rather ought to have come by a petition. And before you come by a petition, you must have waited for the results to be declared before you go and file the action. How do you go and file a writ of summons seeking to attack the validity of a parliamentary election when no results have been declared? And you say that, yes, you can do that one, and you've gone by a writ of summons. So answer JSE went ahead to say as follows. That, and I quote, in the instant case, the plaintiff's writ attacked the very validity of the Akwitia parliamentary election, seeking declaratory and injunctive reliefs. And it goes ahead. The plaintiffs were required by law to have waited for the Electoral Commission to at least declare someone as elected in accordance with Article 46 of the 1992 Constitution and Section 16 of PNDCL 284. Section 16 of PNDCL 284 gave the High Court jurisdiction to entertain an election petition to challenge the validity of a parliamentary election. This provision must be read together with Clause 1, Clause A of Article 1. It must be read together with Clause 1A of Article 99 of the 1992 Constitution, which provides as follows, and I quote, the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member of Parliament has become vacant. And the quote, as that goes ahead, that the Constitution makes a valid assumption that at the time when the High Court assumes jurisdiction, a person has already been elected in the relevant parliamentary election. Thus, by reading the two provisions together, the High Court, in the exercise of its jurisdiction in this matter, is to determine whether the person elected was validly elected or not. Therefore, where no person has been elected in a parliamentary election, assumption of jurisdiction by the High Court is in a matter relating to the validity of the election can only be wrongful within the meaning of plus 1A of Article 99 of the 1992 Constitution. The question for the High Court to determine here is, has someone been validly elected? Thus, while no such someone has been elected in the first place, no issue arises as to whether he was validly elected or not, and the High Court's jurisdiction in the matter is not ripened yet. Quote ends. So what is Ansar GSC saying? That before you can bring an action to challenge the validity of anybody's election, you must wait and make sure that the results of the election have been declared before you can go and bring the action in the High Court. If the results have not been declared and you go and bring any action in the High Court, your action is premature. Your cause of action has not accrued, and you cannot go and then try and go and issue a writ order and say that you didn't bring a petition because no results have been declared. Under Article 99, you must wait for the result to be declared before you can bring an action seeking to attack the validity of anybody's election. Ansar GSC finally concludes as follows, and I quote, "In concluding this point, therefore, the law is that before a person has been declared a winner in a parliamentary election, no action can be brought to challenge the validity of the election, and the High Court similarly lacks jurisdiction to hear same. Even though some other actions may be brought to address electoral irregularities other than to challenge the validity of the election." I'll quote that portion once again. "In concluding this point, therefore, the law is that before a candidate has been declared a winner in a parliamentary election, no action can be brought to challenge the validity of the election, and the High Court similarly lacks jurisdiction to hear same. Even though some other actions may be brought to address electoral irregularities other than to challenge the validity of the election. And therefore, the proceedings in the High Court, where the High Court had wrongfully assumed jurisdiction, they were set aside as void." So what have we said so far in this case of Republic versus the High Court Koforidua, ex parte Dr. Kofi Asare? What we have said so far in this case is that there is a provision in the Representation of People Law, and that is under Section 18 of the Representation of the People Law 1992, which says that an election petition shall be presented within 21 days after the date of the publication in the Gazette of the results of the election to which it relates, but a petition questioning an election or an allegation of corrupt practice, and specifically alleging a payment of money or other award to have been made by the person whose election is questioned or to have been made on behalf of and to that person's knowledge, may be presented within 21 days after the date of the alleged payments. And so people are supposed to be careful to say that, do not say that because Section 18 says that if it's about alleging payment of money, then you can bring the petition within 21 days after the date of the alleged payment. And so even if results have not been declared, you can go and file the action. Never. What's the case of ex parte Collins Dowda and the Republic versus High Court Koforidua, ex parte Dr. Kofi Asare are saying that at all material times, before you can bring an action to challenge the validity of any parliamentary election, first of all, the results must have been declared. And that is why when the High Court in Koforidua assumed jurisdiction, when the results have not been declared, the Supreme Court quashed all the orders made by the High Court, because what the High Court did was a wrongful assumption of jurisdiction, and they didn't have jurisdiction to do so. This is the import of the case of Republic versus the High Court Kufuor, ex parte Dr. Kofi Asare. By way of summary, therefore, this is what we have done so far in this lecture. We have dealt with Article 64, that deals with the procedure for challenging the validity of the election of the president. We said over there that it is the Supreme Court that has jurisdiction, and that action can only be brought by a citizen of Ghana, and the action can be brought within 21 days after the declaration of the results. We've also dealt with the challenging of parliamentary elections. And over there, we dealt with Article 99 of the Constitution. And over there, we mentioned that the court that has the jurisdiction to hear parliamentary election petitions is the High Court. Is the High Court. And we mentioned that from the High Court, the only court that has an appeal when it's a parliamentary election petition is the Court of Appeal, and you cannot bring a further appeal to the Supreme Court. And we buttress that position with parliamentary election for Woodlands constituency, Zakaria and Nimakine. Again, after that one, we now came to look at our case. Our case of Republic versus High Court, Kufuor, ex parte Dr. Kofi Asare, where in that case, we held that when you are bringing any action to challenge the validity of anybody's election as a parliamentarian, under no circumstance will we allow you to bring the action when the results have not been declared. And that you can only bring the action after the results have been declared. That is in relation to the case of Republic versus Kufuor, Republic versus High Court, Kufuor, ex parte Dr. Kofi Asare. That you can only bring the action after the results have been declared. This brings us to the end of our first discussion on challenging presidential and parliamentary elections in Ghana. Thank you.